the president, later the Chief Justice of the Constitutional Court, on his death, was acknowledged by the SACP as having been an underground member of the party for many years.
What I really found interesting in your book is where you delve and explain in more detail cadre deployment. I mean, it's actually obvious now that you think about it, but essentially corruption, the main purpose of cadre deployment, which, I mean, essentially leads to corruption, is actually to benefit the ANC. And primarily by receiving, for example, for every 4 rand that Zuma stole, we seem to think everything went to him, but in actual fact, he perhaps got 1 rand and the ANC got 3 rand. And the cadre deployment really was a way for the ANC to make a lot of money. I think Leon Schreiber says it's incredibly difficult to compete with the ANC's source of funding, which is cadre deployment.
Yes, I think there's absolute validity in that. Because, of course, the ANC primarily deploys cadres into positions of power right across the society, not only in the state, also into business, the media, academia, and so on. But those who are deployed to the state are in a very powerful position to give approval to BEE deals, to give approval to BEE contracts where the state needs to tender particular goods and services. And then if the prices are inflated, as they very often are in about 50% of cases, according to the National Treasury, then it's possible for some of that price inflation to find its way into the pockets of the cadres who drew up the contracts, and from their pockets into the coffers of the ANC. And I think we have evidence of it in some instances. And if one thinks back to the arms deal, which was where corruption really is known to have taken off, it's alleged that the ANC, that bribes of up to $200 million were paid, that some went to the ANC cadres who were responsible for drawing up the contracts, but that a lot of it went to the ANC and helped to fund its 1999 election campaign. And there were similar allegations when the ESCOM build program finally went ahead, and the contract for the boilers, which was a very lucrative contract, went to Hitachi Africa and also to its BEE partner, Chancellor House, which happens to be an acknowledged funding vehicle for the ANC. So again, in that way, the ANC is able to siphon off through its power over the state and the deployment of its cadres a level of resource which no opposition party can begin to match. When it came to the state capture period, there's actually, I think, surprisingly little evidence of how much the ANC itself might have benefited. In the context of the price of locomotives, for example, it was alleged that the ANC had been paid 80 million rand of the billions that were agreed to be paid for the locomotives that ended up being too tall. So some evidence, a little difficult to see, but because we've never had an adequate digging into the extent to which the ANC itself might have benefited.
We are very excited to announce the creation of a new YouTube channel, WorldView Real Stories, a channel that will take you beyond the ordinary. Join us as we venture into the heart of humanity's most captivating narratives. From untold histories to uncharted adventures, get ready to broaden your perspective, challenge your assumptions, witness the incredible diversity of our planet, and the shared experiences that unite us all. Subscribe now to WorldView Real Stories and embark on a journey that will change the way you see the world. What's the status at the moment in terms of the legal route via the DA to end cadre deployment? Is there any hope that cadre deployment can be ended via the courts? Ended?
If the courts were to uphold the Constitution, yes, of course, because it's clearly contrary to the Constitution. There's, first of all, a specific constitutional provision saying that nobody can be appointed for their political membership loyalties. And secondly, we know that cadre deployment undermines the independence of all the key institutions in the Constitution that are supposed to uphold democracy, for one. So the Human Rights Commission, the Gender Commission, the Public Protector, these are institutions that need to be independent. And yet the cadres have been deployed to them and are very often put their loyalties to the ANC before their constitutional obligations, which is what any ANC loyalist would know they are expected to do. So looking at the Constitution's need for independence and for people to act without fear or favor, that's another reason to say that cadre deployment simply can't be accepted. It goes against all those provisions. At the moment, the DA court case is simply looking at whether the minutes for the period when Cyril Ramaphosa, as Deputy President, was chairing the National Deployment Committee, whether those minutes can be released. The ones that we've seen were inadvertently disclosed by the Zondo Commission, but they certainly raise questions and indicate that we need to see them all. The ANC is fighting strongly to say that these are private records of a private organization, rather astonishing claim, and that they shouldn't be disclosed to anybody. So we must see, first of all, how the court rules on that.
A lot of people give a lot of credit to the law, the legal system in South Africa. That's one of the best in the world. I've never met these people, but there are people that say that. And in your book, you lay out how the Constitutional Court, in fact, in many cases, has ruled in favor of the National Democratic Revolution. We seem to forget that the Constitutional Court failed to reinstate the Scorpions. It went to the Constitutional Court and they ruled against the idea of reinstating the Scorpions. Can you give us some examples of how the Constitutional Court has, in fact, partnered with this idea of a national democratic revolution?
Yes, but perhaps before we get to the actual judgments, one must also remember that Arthur Chaskalson, who was the president, later the Chief Justice of the Constitutional Court, on his death was acknowledged by the SACP as having been an underground member of the party for many years. So in many ways, the constitutional negotiations were being shaped by someone with a commitment to the NDR and with enormous influence, because he was such an extraordinarily able jurist. But he also had an underlying wish to see the country move in a particular way. And he sometimes said that the Constitution was geared towards the NDR. What he had in mind, I'm sure, was the socioeconomic rights, which give the state enormous power and which are being used, for example, now in the healthcare sphere to justify the NHI. But we can come to that later. In terms of the court judgments, the Scorpions one was itself a very weak judgment, because the ANC had resolved in December 2007 to disband the Scorpions, our elite existing anti-corruption unit that was clearly independent enough to go after Jacob Zuma and the Travelgate MPs and other deployed cadres. And in 2009, two statutes were adopted, the one to disband the Scorpions and the other to establish the Hawks in their place. And Bob Glenister challenged the constitutional validity of both statutes before the Constitutional Court, saying that South Africa's international and constitutional obligations required it to create and maintain an independent anti-corruption unit. Well, having already created one, what we needed to do was retain it. But the Constitutional Court didn't look at that. They looked instead to whether the Hawks, which were now being created, were sufficiently independent. So having sort of looked at the wording create and maintain, they just ignored and maintain and looked only at create and looked only as if the Hawks were the only contender to be that anti-corruption unit. If they had done what Glenister had asked and looked very carefully as to whether the first statute, the one disbanding the Scorpions, could be upheld in the face of that obligation to create and maintain, then, of course, the Scorpions would have stayed in place. There would have been no need for the Hawks at all, and no need to look at whether the statute establishing them gave them enough independence, which clearly it didn't. And then if one wants to look at other Constitutional Court judgments, I think perhaps one of the most important was in the Agri-SA case in 2013, which involved a mining right which had ceased to exist and so sort of fallen into the custodianship of the state. But the background was really important. The ANC had taken custodianship of all water resources in 1998, of all mineral resources in 2004, when the MPRDA came into existence. And in both instances, it declined to pay any compensation. And yet the market value of the mineral resources admittedly beneath the ground, but still with a great value, was probably about 100 billion. So this was a really important case when it came before the Constitutional Court to decide whether the taking of custodianship qualified as an expropriation for which compensation should be paid. And of course, the case began in the Pretoria High Court, which took the sensible view that whether you call it custodianship or expropriation, what you end up with is all the powers of the erstwhile owner flowing to the state. The state acquires the substance of those powers, and it doesn't really matter whether you call it custodianship or something else. And so the Pretoria High Court said, yep, compensation had to be paid. But when it came to the Constitutional Court, Chief Justice Mogoeng drew a very artificial distinction between the taking of ownership, which he said was the hallmark of expropriation, and the assumption of custodianship, which he implied was a very different thing. And so he ruled that the taking of custodianship did not require the payment of compensation. Enormously useful in the mining context and enormously useful in what lies ahead, because a key purpose of the expropriation bill, now before Parliament, to my mind, is to open the way for the state to take custodianship of land in considerable quantity once that bill is on the statute book. It won't do it directly under the expropriation bill. It'll do it by means of a definition of expropriation in the bill, which narrows it and suggests that the taking of custodianship is something which doesn't qualify for compensation. So that was an enormously useful Constitutional Court judgment, and it really has helped the NDR and will continue to do so.
And I believe you say in your book that we seem to sort of pat ourselves on the backs when we think, oh, the Constitutional Court made a judgment against Zuma that he needs to appear before the Zondo Commission. But in actual fact, they're making a judgment in favor of the ANC because the ANC wants to get rid of him. We forget that because where the Constitutional Court makes judgments in favor of the ANC's factional disputes. And then, we forget about the National Democratic Revolution.
Yes, indeed. It gives the Constitutional Court obviously the appearance of great judicial independence when it rules against Zuma, as it has done pretty consistently on corruption cases. And part of the underlying reason might be that the SACP rightly sees that corruption is a threat to the NDR. The more it accelerates, the more people become disillusioned, the more the ANC is at some risk of losing power, losing its moral legitimacy and credibility. So the SACP very much turned against Jacob Zuma. They wanted to get rid of him. And it was really after that decision was made that the Constitutional Court increasingly firmly ruled against him on the Nkandla issue, criticizing Parliament for not having held him to account, saying that he must appear before the Zondo Commission and then sentencing him to contempt when he failed to do so. So there are a series of judgments there, which are good, sound judgments, which show what the Constitutional Court could do if it had a mind to. But they weren't judgments that raised any ideological issue. When there's an ideological issue, something important to the success of the NDR, then the court will find in a way that supports the NDR.
Do we know anything of Chief Justice Mogoeng's background? In terms of, was he ever a part or a member of the ANC, the South African Communist Party?
I've never found anything about that, but of course one must remember that he was very much criticized when he was being sort of, as it were, pre-selected for the Chief Justice role. If you can cast your mind back to that period, Dikgang Maseneke was widely seen as the most experienced jurist on the court, and therefore the obvious person to be appointed Chief Justice. But he had also been very critical of the ANC, and his background was more PAC than ANC. Chief Justice Mogoeng seemed to have no particular political profile, but he had been a controversial judge in his rather limited time on the bench in the Northwest Division, I suppose it would be, for the former Bophuthatswana. And he was much criticized, for example, for some of his judgments in rape cases where he seemed to be rather sympathetic to the accused. So he came to the Chief Justice position under something of a cloud. And in the midst of allegations that the Judicial Service Commission had really not paid any attention to the other candidates. It had been a sort of slam dunk that Mogoeng was going to be appointed from the time he was nominated or put forward as a candidate. So he perhaps was looking for a case in which he could make his reputation and show his value. And he certainly showed his value to the ANC and the NDR. It was a weak judgment. It hasn't been given all the criticism that it should. And it may in the future not prove as compelling a precedent as the ANC hopes. But certainly Mogoeng in that case proved his value to the NDR. Subsequently, he became, as it were, a sort of defender of judicial independence, particularly at the time of the Omar al-Bashir case, where the High Court, as it was much criticized for having said that the government had acted illegally in allowing him to leave the country. And at that point, Mogoeng did seem to be the great defender of judicial autonomy. But he also agreed that there should be regular meetings between himself as Chief Justice and the heads of Parliament and the President as the head of the executive, in which he said it would be important that they discuss issues. And that sounds horribly like the East German system in which...
that sounds like a terrible idea.
Had been schooled, in which the whole idea is that the courts must harmonize their rulings with what the executive wants. Whether he had that in mind, I don't know. What Zuma said, that he would use these meetings to help harmonize judicial rulings with what the executive wanted.
Yeah, no, I think it would be much better if there's no relationship whatsoever between the judiciary and the executive. It's interesting, Moseneke foreshadows in his book that one day he will tell the story of why he was not appointed a Chief Justice. It'd be interesting to one day hear that story. But, okay, coming back to present time, Ramaphosa, by many people, is sort of seen as ineffective and not decisive. But you suggest in your book that he's actually very effective in one respect, and that is implementing NDR policies.
Yes, I think that Ramaphosa, despite his sort of the way in which he's been depicted as a businessman likely to implement business-friendly reforms, is really deeply committed to the NDR. And I think we saw that very clearly at the SACP's 15th National Congress last year, in which he described the NDR as the joint program of the ANC and the SACP and the reason for the existence of our alliance, and said that the ANC would do absolutely everything it could to defend and advance the NDR. And I think he's been doing that very well in his period as president. There have been a number of important laws that have come forward. And perhaps the most important is the expropriation bill, which has already been passed by the National Assembly, now before the NCOP for endorsement, which allows expropriation for nil compensation or otherwise for very inadequate compensation, and will also, through its definition, its very narrow definition of expropriation, pave the way for further legislation taking custodianship of, say, all agricultural land, as the NVC first proposed in 2014 via a bill that didn't proceed then. Then he's also got through Parliament the Land Court Bill. As you say, people look to the courts to be their bulwark. If there's going to be an expropriation dispute, they assume that the ordinary courts will look dispassionately at all the issues and be a real protection. But the ordinary courts are now to be bypassed via a new land court. And this will allow two-layer assessors to overrule the view of the presiding judge on all matters of fact, and the amount of compensation to be paid could be a matter of fact, in which case it's the layer assessors who will decide in the court.
Sorry, Anthea, just quickly, in terms of hierarchy, the land court, would it be just below the Constitutional Court, Supreme Court of Appeal?
It will have the same status as the ordinary high courts, but it will have the specialized jurisdiction. There was a time when it was planned that there would be a land appeal court too that would ask the jurisdiction of the SCA, Supreme Court of Appeal. That's been changed in the final version of the bill, so there is the possibility of appeal to the Supreme Court of Appeal. But the more litigation there is, the more expensive it is for anybody who has to engage in it, while the state has tax revenues to fall back on. So for most people, the fact that the question of whether they should get no compensation or what amount of compensation could well be tagged as a question of fact, and will then be decided in many instances by two lay assessors who may be land activists. They don't have to be chosen for their independence and their knowledge of the law, and they'll be able to overrule the presiding judge. And we'll be able to dispense with the normal rules of evidence. The whole emphasis will be on speed and informality, which is not conducive to the best legal outcome. So that's an important gain together with the expropriation bill. Then we already have the Employment Equity Amendment Act, which is already through Parliament, already been signed into law, which will allow the minister to set racial targets for businesses employing 50 people or more, which is a great many businesses, plus all the SOEs. And they will have to then really disregard skills, because their requirement will be to comply with demographic representativity. And that approach in the public service has been enormously damaging, really undermining efficiency and competence. And if the same now happens in the private sector, that's an extraordinarily important way of rolling back the capitalist market, because they might not actually be able to survive without the tax revenues, which always, of course, the public service can rely on. Then he's also passed the National Minimum Wage Act, which sets national minimum wages at an extraordinarily high level, and they're going up very fast from where they were first set. And the upshot, as President Ramaphosa is well aware, is that employers incur a loss when they employ people who are inexperienced. So they therefore have no incentive whatsoever to bring in young people who, by definition, have no work experience and often very bad schooling too. And this goes to swell youth unemployment. And that is useful to the NDR because it makes for instability. It increases the revolutionary potential within the country. Then we also have things like the bailout legislation. This is the Basic Education Laws Amendment Bill, which will enormously reduce the autonomy of school governing bodies and will, I think, take away what many parents see as an important safeguard against full state control over education, and so on. And so overall, and this is only a small portion of the interventions that President Ramaphosa has presided over, he's been more effective than any president up to now in implementing the NDR, perhaps because he's president at this particular moment when the NDR is well advanced, but probably also because Zuma, who was expected to do all these things, became sidetracked by state capture and padding his own pockets to a very obvious extent.
To a certain degree, then, it would perhaps be better if our president was corrupt in comparison to the worst case scenario. But, I mean, you're the expert. I would love to hear your opinion on this. In terms of the land issue, a person like Dr. Piet Krokamp likes to say that the average person that takes the money as opposed to the land because the process is so long. Is that true?
Yeah, the average person certainly takes the money. We're talking here about land restitution, where it's been possible since 1994 for people who were dispossessed of land in the apartheid era to claim either that particular land back or some other compensation. And there were about 80,000 claims lodged in the initial window period, which expired in December 1998, most of which have been settled. But the great bulk, more than 90% of the successful claimants, chose to take cash rather than land. And why was that? Because the government is fundamentally wrong in thinking that there's this enormous land hunger. South Africa is a rapidly urbanizing society. We already have well over 60% urbanization, and that is soon going to reach 70%. And most people don't want a patch of land in the countryside to try and till. They want houses and jobs and income in the urban areas. So, of course, the restitution process has been very slow and drawn out. But I think even without that, most people would have wanted to take cash instead. As Gugile and Quinte, then land minister, said, we no longer have a peasantry. Yeah.
Okay, but I think what a person like Picot is suggesting, that there might actually be a land hunger, but a person would rather take the money now than wait 3 years to get the land. So it's not necessarily a question of having the intention to want land or not. The process is just too long to actually acquire the land as versus getting the money right now.
Yes, I guess there is that element as well, because even if you have put in a claim that's been successful, the whole process of actually, in the end, getting that piece of land, which you don't own, which will always be transferred either to a traditional authority or a communal property association. So it's another reason to think that the money in your pocket, which you do own, is a more tangible benefit. I think, too, that where there is a hunger is for urban land for housing, and for housing itself, of course. And so, the IRRs has come with ideas of how one could actually take the current very flawed and often corrupt process with houses being very badly built, and turn it into something that would be much more efficient and would give people the benefit of private sector competition and innovation.
Which would be?
Housing vouchers, tax-funded housing vouchers. So in other words, you took some of the money that's being so badly spent by the state, and its housing delivery has also fallen off enormously, partly because municipalities take such a long time to give all the approvals to take a piece of ground from land to stand, as the jargon goes. So if you gave people, first of all, you improve the efficiency of the municipality so that the stands are available, and people had tax-funded housing vouchers, then they wouldn't have to wait 20 years or more for the government to come along and contract with some probably BEE contractor who may pocket half of the money and walk off having done a very shoddy job, as has happened, unfortunately, very often. Instead, people would want to use that money the best possible way for their own advantage. And so you could have an immediate efficiency in the running of housing operations, which you don't get now. People would either be able to get mortgages from the bank, or they could go to the private sector, which would now be competing for these all consumers with the benefit of tax-funded vouchers. And if the government bowed out of the low-cost housing program and wasn't competing with the private sector, then there'd also be more interest in people buying their own homes. Now, a lot of the problem is people say, well, we don't want to spend 180,000 rand on a home because we can get one free from the government. And so they wait endlessly for that free house. Whereas with the help of the money and with the private sector able to compete, able to innovate, and able to deliver, the housing problem could be resolved much more easily than we see now.
Interesting, and I can easily see you emulating that in all sectors of society: education, healthcare, the same principle.